Hi, my name is Henry Pan. I have a personal injury practice in Aliso Viejo, California. Recently, a lot of my friends and colleagues who are business owners have been asking me about California Assembly Bill number 5 and the recent California Supreme Court decision in Dynamex Operations West, Inc. versus Superior Court of Los Angeles. Their concern in the issue in that case was the misclassification of workers as independent contractors versus employees. Even though this sounds like an employment law issue, the classification of a person as an employee or an independent contractor has significant implications in the personal injury context. This is because an employer is liable for the negligence of his employee if they are within the course and scope of their employment. But before talking about AB5 and Dynamex, one must first talk about SG Borello and Sons Inc. versus Department of Industrial Relations. Whenever the status of a worker as an employee is disputed, the Borello case is used to determine the classification of the worker. The primary inquiry is whether the hiring party had the right to control how the person performed the work, rather than just the right to specify the result. The case also lists multiple secondary factors that may speak to the relationship as well. So on April 30th, 2018, the California Supreme Court issued a decision in the Dynamex case, which created a presumption that a worker who performs services for a hirer is an employee for purposes of claims for wages and benefits. California has recently codified the decision in Dynamex into the California Labor Code, effective January 1, 2020. The newly added section 2750.3 creates a presumption that a person providing labor for money is an employee unless a three-part test is met. This is now sometimes referred to as the ABC test. Similar to the primary Borello factor, the first part of the Dynamex test, part A, is whether the person providing labor is free from the hiring party's control regarding performance of the work. The rationale is that an employer can control how their employees do their work, whereas an independent contractor typically is performing some specialized work without oversight and control. The second Dynamex factor, part B, is whether the work being done was outside the usual course of the hiring party's business. The idea here is that if you hire someone to do the exact work that is part of your regular business, then that is one indicia of employee rather than independent contractor status. The final factor, part C, is whether the person hired was engaged in an independently established trade, occupation, or business for the same type of work performed. Here, the rationale is that an individual who does not operate his own business and solely relies on the work from a single employer is likely its employee. Thus, all three factors must be true in order to defeat the presumption of employee status and classify a worker as an independent contractor for purposes of the Labor Code, Unemployment Insurance Code, and for wage orders of the Industrial Welfare Commission. So why does this matter to you? Well, the willful misclassification of a worker as an independent contractor can lead to civil penalties ranging from $5,000 to $15,000 per misclassification. And further, if there's a determination that there's a pattern or practice of these violations, the penalties can range from $10,000 to $25,000 for each violation. However, the legislature created multiple exemptions from the ABC test for certain qualifying professions and business service providers. These exemptions are numerous and nuanced. Therefore, we've created a flowchart for you to help make sense of the new statute. For more information on how this may affect your business, visit panlawgroup.com or give us a call for a free consultation. Thank you very much.